Hello, Colorado Realtors. I'm Scott Peterson, and thank you for joining me for another edition of Legal Bites. So you're really fortunate that you joined me for this one today, because we're going to answer a question that's not just a real estate question, it's really a life question on Legal Bites today. And that question is, TB or not TB? That is the question. I can't believe I just did that. This is, when is agency the only option? So TB, of course, in this case is not to be or not to be, but it's TB is in transaction broker. Okay? When is agency your only option in terms of a relationship with a client? Okay? The question is, can you be neutral in evaluating that? So pursuant to Colorado license law, there's only two working relationships that you can actually have with a client. We all know that, correct? The relationships that are available to licensees in their engagement with a client is either going to be as that client's agent or as a transaction broker, a TB in this case. So that said, there are certain situations under the law where there's only one relationship that's appropriate, and that's going to be the agency relationship. And that's because as a TB, you're supposed to remain neutral. You're supposed to be in between a transaction and helping facilitate a transaction, not advocating for one client or another, versus an agency relationship where that's a requirement. You have that fiduciary obligation. And so there's going to be situations that you all come into, and we get them a lot on the Car Legal Hotline, where somebody says, listen, I don't know if I can act as a TB in this transaction. And if you're asking yourself that question, you really, really need to evaluate it, okay? So Commission Position Statement 31, I love citing commission position statements. They're actually a really nice tool that I think we use well from a regulatory standpoint and for clarification on things. CP 31 is what provides us some guidance on this. And so you're an agent only is your only option. You can't be a TB in a few situations that are very, very clear. And they get kind of progressively more gray depending on the facts and circumstances. In the first example, if you're a broker and you're acting as a principal, you cannot be a transaction broker on that. You're going to have to act as your own agent, and you're going to have to treat the other party, whether it's a buyer or seller, as a customer. Okay? No obligation to them whatsoever, and you better make darn sure that you've got the appropriate disclosures related to the fact that you're a licensed agent and that you've given brokerage disclosures to the other party that you're going to treat them as a customer in that case. Very, very clear there, no gray area whatsoever. And I would add that that even includes a situation where maybe you're a member of an LLC or a partnership as a broker, and you have a partial ownership interest in a property or a partial ownership interest in a LLC that's going to be purchasing a property. Still, you have to, in that case, act as an agent because you do have ownership interest, and you better be making those disclosures. I would disclose to the other party that you are a licensed broker and that you have an ownership interest in the entity and that you're treating them as a customer. So second situation would be if broker's family member is a principal. You know, this is where it starts to get a little bit more gray. If this is your spouse or your child, your sibling, a very immediate family member, then there's no question you're going to have to act as their agent in the transaction and not as a transaction broker. The further away you get, you got to be cautious. And again, if you've got a family member, I would almost encourage you, even if you're talking about a second cousin, if you have that sort of ongoing relationship, you've grown up together, very, very close, you're going to be an agent in that situation. The more, I don't want to say tenuous the relationship gets, but the less there is this close relationship, the greater opportunity you would have to be neutral in that situation. I would still absolutely disclose it, even if it's a second cousin that you really have not had any encounters or time with at all in your life. You still want to make that disclosure, but it gets to be if you're far enough away and you don't have enough of a relationship where maybe you could act as a TB. But again, your safest bet's going to be agent in that situation. Next one's going to be broker's close friend or business associate. Business associate's the principal. Very likely, once again, if this is your best friend, they're not your family member, they're going to be closer to you than your second cousin that you haven't really spent much time in your life with. So in that situation, you're going to want to act as a agent to your friend or your close business associate. Don't try and act as a TB if you can't be neutral because you've got a close personal relationship with somebody. And then the last situation is a broker's regular client as a principal. And this is where it comes up more often. If you work with a buyer, an investor buyer as an example, and they're buying properties left and right, or you've done 4, 5, 10, 20, 100 transactions with somebody, the more invested you are in that relationship, the more difficult or impossible in some cases it's going to be for you to act as a neutral transaction broker in the transaction. So you're going to have to act as an agent. If you're doing repeated business with the same client over and over, agency is almost always going to be your default relationship in that situation. So you got to be very, very cautious in those gray areas and disclose. Make sure the other party understands the relationship, understands that you're a licensed real estate broker in the state of Colorado, and that they understand that in the cases where you're acting as an agent, that they are a customer. And make darn sure if you're going to try and act as a transaction broker and you're anywhere near the gray area, that you're actually acting as a transaction broker and that you're not acting as an agent for one of the parties that are within that gray area. So anyhow, I hope that clarifies some things. I do get an awful lot of questions on the hotline about some of the more gray areas, and always like to talk about the commission position statement. So if you have more specific questions or want to talk to a qualified attorney and you're a member of the Realtor Association, you can always call the legal hotline. It's available from 9 to 12 and 1 to 4, Monday through Friday. Thanks for your membership in the association, and thanks for joining us for another edition of Legal Bites.